Be ready. 5 seconds. Learned counsel states that the appellant has been wrongly convicted. Stop. Despite the fact that the premises of the petitioner was searched pursuant to the information, no videography or photography of the spot or even the residence was conducted to lend credence to the version of the investigating agency. Stop. The investigating officer who appeared as PW9 clearly deposed that he did not take photographs of the premises of the appellant or of co-accused, and further, no photographs of recovery and search proceedings were also taken. Stop. The investigating agency failed to even prepare the site plan of the spot where raids were allegedly carried out. Stop. Reliance is placed on the decisions of this court reported as 2014 146 DRJ 629 Ram Prakash versus State. Stop. The samples were drawn in breach of Section 52A of the NDPS Act and contrary to the law laid down by the Honorable Supreme Court. Stop. The evidence of the independent witnesses who were examined as PW5 and PW6 respectively is not worthy of credit. Stop. There are material contradictions in the testimony of the two independent witnesses. Stop. The independent witnesses have also contradicted the evidence of official witnesses in respect of time when the raid was conducted. Stop para. Learned counsel for appellant states that her conviction is based on the testimony of Jyoti Rawat, who identifies her as the person who booked the courier, however, there is no record to prove the same. Stop. No register in relation thereto has been proved by the prosecution. Stop. The appellant has been falsely implicated in the case and no recovery has been made from her possession or pursuant to her disclosure. Stop. The appellant's husband died long back and she has a son to look after, thus a compassionate view be taken. Stop para. Learned counsel for the NCB submits that contention of learned counsel for the appellant that the samples allegedly recovered were drawn and seized contrary to the NDPS Act and the guidelines issued by the respondent deserves to be rejected. Stop. There is no violation of any provision of the Act, much less Section 52A. Stop. Further, Standing Order number 1/88 and 1/89 are mere internal advisory guidelines of the department and have been duly complied with and have not been notified in the Gazette and thus not statutory law. Stop para. In view of the law laid down by the Supreme Court, if the only evidence against an accused is his statement recorded under Section 67, the said confessional statement cannot be taken into consideration to convict the accused. Stop para. However, this contradiction does not go to the root of the matter because both the witnesses have consistently stated that there were number of people and thus in a melee, the oversight as to who came first can always be there. Stop. This witness in cross-examination further stated that Stanley even tried to run away by pushing him but was caught hold by NCB officials. Stop para. Learned counsel for the appellant has emphasized on the fact that in the Panchnama there is an overwriting in the weight of recovery as in the middle number 5, double quote 255 quote close has been overwritten. Stop. It may be noted that overwriting is only on the number 5 in the middle and the witness who prepared these documents was not cross-examined on this aspect though he was extensively cross-examined on other aspects. Stop. Thus, though mixing of the contraband recovered from the courier agencies was resorted to, but the same was not the case for recovery from the room of Stanley. Stop para. Consequently, the conviction and sentence awarded to the appellants are upheld, however, the impugned judgment and order on sentence qua Stephen is set aside. Superintendent Tihar Jail is directed to release the appellant.